Agreement for the implementation of the provisions of the United Nations Convention on the Law of the Sea of 10 December 1982 relating to the conservation and management of straddling fish stocks and highly migratory fish stocks. Done at New York on 4 August 1995, entry into force, the 11th of December 2001. The states parties to this agreement. Recalling the relevant provisions of the United Nations Convention on the Law of the Sea of 10 December 1982, determined to ensure the long-term conservation and sustainable use of straddling fish stocks and highly migratory fish stocks. Resolved to improve cooperation between states to that end. Calling for more effective enforcement by flag states, port states and coastal states of the conservation and management measures adopted for such stocks. Seeking to address in particular the problems identified in Chapter 17, Program Area C, of Agenda 21 adopted by the United Nations Conference on Environment and Development, namely, that the management of high seas fisheries is inadequate in many areas and that some resources are overutilized, noting that there are problems of unregulated fishing, overcapitalization, excessive fleet size, vessel reflagging to escape controls, insufficiently selective gear, unreliable databases and lack of sufficient cooperation between states. Committing themselves to responsible fisheries. Conscious of the need to avoid adverse impacts on the marine environment, preserve biodiversity, maintain the integrity of marine ecosystems and minimize the risk of long-term or irreversible effects of fishing operations. Recognizing the need for specific assistance, including financial, scientific and technological assistance, in order that developing states can participate effectively in the conservation, management and sustainable use of straddling fish stocks and highly migratory fish stocks. Convinced that an agreement for the implementation of the relevant provisions of the Convention would best serve these purposes and contribute to the maintenance of international peace and security. Affirming that matters not regulated by the Convention or by this agreement continue to be governed by the rules and principles of general international law. Have agreed as follows. Part 1. General Provisions, Article 1. Use of terms and scope. 1. For the purposes of this agreement. A. Convention means the United Nations Convention on the Law of the Sea of 10 December 1982. B. Conservation and management measures means measures to conserve and manage one or more species of living marine resources that are adopted and applied consistent with the relevant rules of international law as reflected in the Convention and this agreement. C. Fish includes mollusks and crustaceans except those belonging to sedentary species as defined in Article 77 of the Convention. And D. Arrangement means a cooperative mechanism established in accordance with the Convention and this agreement by two or more states for the purpose, inter alia, of establishing conservation and management measures in a sub-region or region for one or more straddling fish stocks or highly migratory fish stocks. 2. A states parties means states which have consented to be bound by this agreement and for which the agreement is in force. B. This agreement applies mutatis mutandis, I, to any entity referred to in Article 305, Paragraph 1, C, D, and E, of the Convention, and 2, subject to Article 47, to any entity referred to as an international organization in Annex 9, Article 1, of the Convention which becomes a party to this agreement, and to that extent states parties refers to those entities. 3. This agreement applies mutatis mutandis to other fishing entities whose vessels fish on the high seas. Article 2. Objective. The objective of this agreement is to ensure the long-term conservation and sustainable use of straddling fish stocks and highly migratory fish stocks through effective implementation of the relevant provisions of the Convention. Article 3. Application. 1. Unless otherwise provided, This agreement applies to the conservation and management of straddling fish stocks and highly migratory fish stocks beyond areas under national jurisdiction, except that Articles 6 and 7 apply also to the conservation and management of such stocks within areas under national jurisdiction, subject to the different legal regimes that apply within areas under national jurisdiction and in areas beyond national jurisdiction as provided for in the Convention. 2. In the exercise of its sovereign rights for the purpose of exploring and exploiting, conserving and managing straddling fish stocks and highly migratory fish stocks within areas under national jurisdiction, the coastal state shall apply mutatis mutandis the general principles enumerated in Article 5. 3. States shall give due consideration to the respective capacities of developing states to apply Articles 5, 6 and 7 within areas under national jurisdiction and their need for assistance as provided for in this agreement. To this end, Part 7 applies mutatis mutandis in respect of areas under national jurisdiction. Article 4. Relationship between this agreement and the Convention. Nothing in this agreement shall prejudice the rights, jurisdiction and duties of states under the Convention. This agreement shall be interpreted and applied in the context of and in a manner consistent with the Convention. Part 2. Conservation and management of straddling fish stocks and highly migratory fish stocks, Article 5. General principles. In order to conserve and manage straddling fish stocks and highly migratory fish stocks, coastal states and states fishing on the high seas shall, in giving effect to their duty to cooperate in accordance with the Convention. A. Adopt measures to ensure long-term sustainability of straddling fish stocks and highly migratory fish stocks and promote the objective of their optimum utilization. B. Ensure that such measures are based on the best scientific evidence available and are designed to maintain or restore stocks at levels capable of producing maximum sustainable yield, as qualified by relevant environmental and economic factors, including the special requirements of developing states, and taking into account fishing patterns, the interdependence of stocks and any generally recommended international minimum standards, whether sub-regional, regional or global. C. Apply the precautionary approach in accordance with Article 6. D. Assess the impacts of fishing, other human activities and environmental factors on target stocks and species belonging to the same ecosystem or associated with or dependent upon the target stocks. E. Adopt, where necessary, conservation and management measures for species belonging to the same ecosystem or associated with or dependent upon the target stocks, with a view to maintaining or restoring populations of such species above levels at which their reproduction may become seriously threatened. F. Minimize pollution, waste, discards, catch by lost or abandoned gear, catch of non-target species, both fish and non-fish species, hereinafter referred to as non-target species, and impacts on associated or dependent species, in particular endangered species, through measures including, to the extent practicable, the development and use of selective, environmentally safe and cost-effective fishing gear and techniques. G. Protect biodiversity in the marine environment. H. Take measures to prevent or eliminate overfishing and excess fishing capacity and to ensure that levels of fishing effort do not exceed those commensurate with the sustainable use of fishery resources. I. Take into account the interests of artisanal and subsistence fishers. J. Collect and share, in a timely manner, complete and accurate data concerning fishing activities on, inter alia, vessel position, catch of target and non-target species and fishing effort, as set out in Annex I, as well as information from national and international research programs. K. Promote and conduct scientific research and develop appropriate technologies in support of fishery conservation and management and L. Implement and enforce conservation and management measures through effective monitoring, control and surveillance. Article 6. Application of the precautionary approach. 1. States shall apply the precautionary approach widely to conservation, management and exploitation of straddling fish stocks and highly migratory fish stocks in order to protect the living marine resources and preserve the marine environment. 2. States shall be more cautious when information is uncertain, unreliable or inadequate. The absence of adequate scientific information shall not be used as a reason for postponing or failing to take conservation and management measures. 3. In implementing the precautionary approach, states shall a. Improve decision-making for fishery resource conservation and management by obtaining and sharing the best scientific information available and implementing improved techniques for dealing with risk and uncertainty. b. Apply the guidelines set out in Annex 2 and determine, on the basis of the best scientific information available, stock-specific reference points and the action to be taken if they are exceeded. c. Take into account, inter alia, uncertainties relating to the size and productivity of the stocks, reference points, stock condition in relation to such reference points, levels and distribution of fishing mortality and the impact of fishing activities on non-target and associated or dependent species, as well as existing and predicted oceanic, environmental and socio-economic conditions, and d. Develop data collection and research programs to assess the impact of fishing on non-target and associated or dependent species and their environment, and adopt plans which are necessary to ensure the conservation of such species and to protect habitats of special concern. 4. States shall take measures to ensure that, when reference points are approached, they will not be exceeded. In the event that they are exceeded, states shall, without delay, take the action determined under paragraph 3b, to restore the stocks. 5. Where the status of target stocks or non-target or associated or dependent species is of concern, states shall subject such stocks and species to enhanced monitoring in order to review their status and the efficacy of conservation and management measures. They shall revise those measures regularly in the light of new information. 6. For new or exploratory fisheries, states shall adopt as soon as possible cautious conservation and the management measures, including, inter alia, catch limits and effort limits. Such measures shall remain in force until there are sufficient data to allow assessment of the impact of the fisheries on the long-term sustainability of the stocks, whereupon conservation and management measures based on that assessment shall be implemented. The latter measures shall, if appropriate, allow for the gradual development of the fisheries. 7. If a natural phenomenon has a significant adverse impact on the status of straddling fish stocks or highly migratory fish stocks, states shall adopt conservation and management measures on an emergency basis to ensure that fishing activity does not exacerbate such adverse impact. States shall also adopt such measures on an emergency basis where fishing activity presents a serious threat to the sustainability of such stocks. Measures taken on an emergency basis shall be temporary and shall be based on the best scientific evidence available. Article 7. Compatibility of conservation and management measures. 1. Without prejudice to the sovereign rights of coastal states for the purpose of exploring and exploiting, conserving and managing the living marine resources within areas under national jurisdiction as provided for in the Convention, and the right of all states for their nationals to engage in fishing on the high seas in accordance with the Convention. A. With respect to straddling fish stocks, the relevant coastal states and the states whose nationals fish for such stocks in the adjacent high seas area shall seek, either directly or through the appropriate mechanisms for cooperation provided for in Part 3, to agree upon the measures necessary for the conservation of these stocks in the adjacent high seas area. B. With respect to highly migratory fish stocks, the relevant coastal states and other states whose nationals fish for such stocks in the region shall cooperate. either directly or through the appropriate mechanisms for cooperation provided for in Part 3, with a view to ensuring conservation and promoting the objective of optimum utilization of such stocks throughout the region, both within and beyond the areas under national jurisdiction. 2. Conservation and management measures established for the high seas and those adopted for areas under national jurisdiction shall be compatible in order to ensure conservation and management of the straddling fish stocks and highly migratory fish stocks in their entirety. To this end, coastal states and states fishing on the high seas have a duty to cooperate for the purpose of achieving compatible measures in respect of such stocks. In determining compatible conservation and management measures, states shall a. Take into account the conservation and management measures adopted and applied in accordance with Article 61 of the Convention in respect of the same stocks by coastal states within areas under national jurisdiction and ensure that measures established in respect of such stocks for the high seas do not undermine the effectiveness of such measures. b. Take into account previously agreed measures established and applied for the high seas in accordance with the Convention in respect of the same stocks by relevant coastal states and states fishing on the high seas. c. Take into account previously agreed measures established and applied in accordance with the Convention in respect of the same stocks by a sub-regional or regional fisheries management organization or arrangement. d. Take into account the biological unity and other biological characteristics of the stocks and the relationships between the distribution of the stocks, the fisheries and the geographical particularities of the region concerned, including the extent to which the stocks occur and are fished in areas under national jurisdiction. e. Take into account the respective dependence of the coastal states and the states fishing on the high seas on the stocks concerned and f. Ensure that such measures do not result in harmful impact on the living marine resources as a whole. 3. In giving effect to their duty to cooperate, states shall make every effort to agree on compatible conservation and management measures within a reasonable period of time. 4. If no agreement can be reached within a reasonable period of time, any of the states concerned may invoke the procedures for the settlement of disputes provided for in Part 8. 5. Pending agreement on compatible conservation and management measures, the states concerned, in a spirit of understanding and cooperation, shall make every effort to enter into provisional arrangements of a practical nature. In the event that they are unable to agree on such arrangements, any of the states concerned may, for the purpose of obtaining provisional measures, submit the dispute to a court or tribunal in accordance with the procedures for the settlement of disputes provided for in Part 8. 6. Provisional arrangements or measures entered into or prescribed pursuant to Paragraph 5 shall take into account the provisions of this part, shall have due regard to the rights and obligations of all states concerned, shall not jeopardize or hamper the reaching of final agreement on compatible conservation and management measures and shall be without prejudice to the final outcome of any dispute settlement procedure. 7. Coastal states shall regularly inform states fishing on the high seas in the sub-region or region, either directly or through appropriate sub-regional or regional fisheries management organizations or arrangements, or through other appropriate means, of the measures they have adopted for straddling fish stocks and highly migratory fish stocks within areas under their national jurisdiction. 8. States fishing on the high seas shall regularly inform other interested states, either directly or through appropriate sub-regional or regional fisheries management organizations or arrangements, or through other appropriate means, of the measures they have adopted for regulating the activities of vessels flying their flag which fish for such stocks on the high seas. Part 3. Mechanisms for international cooperation concerning straddling fish stocks and highly migratory fish stocks, Article 8. Cooperation for conservation and management. 1. Coastal states and states fishing on the high seas shall, in accordance with the Convention, pursue cooperation in relation to straddling fish stocks and highly migratory fish stocks either directly or through appropriate sub-regional or regional fisheries management organizations or arrangements, taking into account the specific characteristics of the sub-region or region, to ensure effective conservation and management of such stocks. 2. States shall enter into consultations in good faith and without delay, particularly where there is evidence that the straddling fish stocks and highly migratory fish stocks concerned may be under threat of overexploitation or where a new fishery is being developed for such stocks. To this end, consultations may be initiated at the request of any interested state with a view to establishing appropriate arrangements to ensure conservation and management of the stocks. Pending agreement on such arrangements, states shall observe the provisions of this agreement and shall act in good faith and with due regard to the rights, interests and duties of other states. 3. Where a sub-regional or regional fisheries management organization or arrangement has the competence to establish conservation and management measures for particular straddling fish stocks or highly migratory fish stocks, states fishing for the stocks on the high seas and relevant coastal states shall give effect to their duty to cooperate by becoming members of such organization or participants in such arrangement, or by agreeing to apply the conservation and management measures established by such organization or arrangement. States having a real interest in the fisheries concerned may become members of such organization or participants in such arrangement. The terms of participation in such organization or arrangement shall not preclude such states from membership or participation, nor shall they be applied in a manner which discriminates against any state or group of states having a real interest in the fisheries concerned. 4. Only those states which are members of such an organization or participants in such an arrangement, or which agree to apply the conservation and management measures established by such organization or arrangement, shall have access to the fishery resources to which those measures apply. 5. Where there is no sub-regional or regional fisheries management organization or arrangement to establish conservation and management measures for a particular straddling fish stock or highly migratory fish stock, relevant coastal states and states fishing on the high seas for such stock in the sub-region or region shall cooperate to establish such an organization or enter into other appropriate arrangements to ensure conservation and management of such stock and shall participate in the work of the organization or arrangement. 6. Any state intending to propose that action be taken by an intergovernmental organization having competence with respect to living resources should, where such action would have a significant effect on conservation and management measures already established by a competent sub-regional or regional fisheries management organization or arrangement, consult through that organization or arrangement with its members or participants. To the extent practicable, such consultation should take place prior to the submission of the proposal to the intergovernmental organization. Article 9. Sub-regional and regional fisheries management organizations and arrangements. 1. In establishing sub-regional or regional fisheries management organizations or in entering into sub-regional or regional fisheries management arrangements for straddling fish stocks and highly migratory fish stocks, states shall agree, inter alia, on a. The stocks to which conservation and management measures apply, taking into account the biological characteristics of the stocks concerned and the nature of the fisheries involved. b. The area of application, taking into account Article 7, Paragraph 1, and the characteristics of the sub-region or region, including socio-economic, geographical and environmental factors. c. The relationship between the work of the new organization or arrangement and the role, objectives and operations of any relevant existing fisheries management organizations or arrangements, and d. The mechanisms by which the organization or arrangement will obtain scientific advice and review the status of the stocks, including, where appropriate, the establishment of a scientific advisory body. 2. States cooperating in the formation of a sub-regional or regional fisheries management organization or arrangement shall inform other states which they are aware have a real interest in the work of the proposed organization or arrangement of such cooperation. Article 10. Functions of sub-regional and regional fisheries management organizations and arrangements. In fulfilling their obligation to cooperate through sub-regional or regional fisheries management organizations or arrangements, states shall a. Agree on and comply with conservation and management measures to ensure the long-term sustainability of straddling fish stocks and highly migratory fish stocks. b. Agree, as appropriate, on participatory rights such as allocations of allowable catch or levels of fishing effort. c. Adopt and apply any generally recommended international minimum standards for the responsible conduct of fishing operations. d. Obtain and evaluate scientific advice, review the status of the stocks and assess the impact of fishing on non-target and associated or dependent species. e. Agree on standards for collection, reporting, verification and exchange of data on fisheries for the stocks. f. Compile and disseminate accurate and complete statistical data, as described in Annex I. To ensure that the best scientific evidence is available, while maintaining confidentiality where appropriate. g. Promote and conduct scientific assessments of the stocks and relevant research and disseminate the results thereof. h. Establish appropriate cooperative mechanisms for effective monitoring, control, surveillance and enforcement. I. Agree on means by which the fishing interests of new members of the organization or new participants in the arrangement will be accommodated. j. Agree on decision-making procedures which facilitate the adoption of conservation and management measures in a timely and effective manner. k. Promote the peaceful settlement of disputes in accordance with Part 8. 1. Ensure the full cooperation of their relevant national agencies and industries in implementing the recommendations and decisions of the organization or arrangement and m. Give due publicity to the conservation and management measures established by the organization or arrangement. Article 11. New members or participants. In determining the nature and extent of participatory rights for new members of a sub-regional or regional fisheries management organization, or for new participants in a sub-regional or regional fisheries management arrangement, states shall take into account, inter alia, a. The status of the straddling fish stocks and highly migratory fish stocks and the existing level of fishing effort in the fishery. b. The respective interests, fishing patterns and fishing practices of new and existing members or participants. c. The respective contributions of new and existing members or participants to conservation and management of the stocks, to the collection and provision of accurate data and to the conduct of scientific research on the stocks. d. The needs of coastal fishing communities which are dependent mainly on fishing for the stocks. e. The needs of coastal states whose economies are overwhelmingly dependent on the exploitation of living marine resources and f. The interests of developing states from the sub-region or region in whose areas of national jurisdiction the stocks also occur. Article 12. Transparency in activities of sub-regional and regional fisheries management organizations and arrangements. 1. States shall provide for transparency in the decision-making process and other activities of sub-regional and regional fisheries management organizations and arrangements. 2. Representatives from other intergovernmental organizations and representatives from non-governmental organizations concerned with straddling fish stocks and highly migratory fish stocks shall be afforded the opportunity to take part in meetings of sub-regional and regional fisheries management organizations and arrangements as observers or otherwise, as appropriate, in accordance with the procedures of the organization or arrangement concerned. Such procedures shall not be unduly restrictive in this respect. Such intergovernmental organizations and non-governmental organizations shall have timely access to the records and reports of such organizations and arrangements, subject to the procedural rules on access to them. Article 13. Strengthening of existing organizations and arrangements. States shall cooperate to strengthen existing sub-regional and regional fisheries management organizations and arrangements in order to improve their effectiveness in establishing and implementing conservation and management measures for straddling fish stocks and highly migratory fish stocks. Article 14. Collection and provision of information and cooperation in scientific research. 1. States shall ensure that fishing vessels flying their flag provide such information as may be necessary in order to fulfill their obligations under this agreement. To this end, states shall, in accordance with Annex I.A., collect and exchange scientific, technical and statistical data with respect to fisheries for straddling fish stocks and highly migratory fish stocks. B. Ensure that data are collected in sufficient detail to facilitate effective stock assessment and are provided in a timely manner to fulfill the requirements of sub-regional or regional fisheries management organizations or arrangements, and c. Take appropriate measures to verify the accuracy of such data. 2. States shall cooperate, either directly or through sub-regional or regional fisheries management organizations or arrangements. A. To agree on the specification of data and the format in which they are to be provided to such organizations or arrangements, taking into account the nature of the stocks and the fisheries for those stocks, and b. To develop and share analytical techniques and stock assessment methodologies to improve measures for the conservation and management of straddling fish stocks and highly migratory fish stocks. 3. Consistent with Part 13 of the Convention, states shall cooperate, either directly or through competent international organizations, to strengthen scientific research capacity in the field of fisheries and promote scientific research related to the conservation and management of straddling fish stocks and highly migratory fish stocks for the benefit of all. To this end, a state or the competent international organization conducting such research beyond areas under national jurisdiction shall actively promote the publication and dissemination to any interested states of the results of that research and information relating to its objectives and methods, and, to the extent practicable, shall facilitate the participation of scientists from those states in such research. Article 15. Enclosed and semi-enclosed seas. In implementing this agreement in an enclosed or semi-enclosed sea, states shall take into account the natural characteristics of that sea and shall also act in a manner consistent with Part 9 of the Convention and other relevant provisions thereof. Article 16. Areas of high sea surrounded entirely by an area under the national jurisdiction of a single state. 1. States fishing for straddling fish stocks and highly migratory fish stocks in an area of the high seas surrounded entirely by an area under the national jurisdiction of a single state, and the latter state shall cooperate to establish conservation and management measures in respect of those stocks in the high seas area. Having regard to the natural characteristics of the area, states shall pay special attention to the establishment of compatible conservation and management measures for such stocks pursuant to Article 7. Measures taken in respect of the high seas shall take into account the rights, duties and interests of the coastal state under the Convention, shall be based on the best scientific evidence available, and shall also take into account any conservation and management measures adopted and applied in respect of the same stocks in accordance with Article 61 of the Convention by the coastal state in the area under national jurisdiction. States shall also agree on measures for monitoring, control, surveillance and enforcement to ensure compliance with the conservation and management measures in respect of the high seas. 2. Pursuant to Article 8, states shall act in good faith and make every effort to agree without delay on conservation and management measures to be applied in the carrying out of fishing operations in the area referred to in paragraph 1. If, within a reasonable period of time, the fishing states concerned and the coastal state are unable to agree on such measures, they shall, having regard to paragraph 1, apply Article 7, paragraphs 4, 5 and 6, relating to provisional arrangements or measures. Pending the establishment of such provisional arrangements or measures, the states concerned shall take measures in respect of vessels flying their flag in order that they not engage in fisheries which could undermine the stocks concerned. Part 4. Non-members and non-participants. Article 17. Non-members of organizations and non-participants in arrangements. 1. A state which is not a member of a sub-regional or regional fisheries management organization or is not a participant in a sub-regional or regional fisheries management arrangement, and which does not otherwise agree to apply the conservation and management measures established by such organization or arrangement, is not discharged from the obligation to cooperate, in accordance with the Convention and this agreement, in the conservation and management of the relevant straddling fish stocks and highly migratory fish stocks. 2. Such state shall not authorize vessels flying its flag to engage in fishing operations for the straddling fish stocks or highly migratory fish stocks which are subject to the conservation and management measures established by such organization or arrangement. 3. States which are members of a sub-regional or regional fisheries management organization or participants in a sub-regional or regional fisheries management arrangement shall, individually or jointly, request the fishing entities referred to in Article 1, paragraph 3, which have fishing vessels in the relevant area to cooperate fully with such organization or arrangement in implementing the conservation and management measures it has established, with a view to having such measures applied de facto as extensively as possible to fishing activities in the relevant area. Such fishing entities shall enjoy benefits from participation in the fishery commensurate with their commitment to comply with conservation and management measures in respect of the stocks. 4. States which are members of such organization or participants in such arrangement shall exchange information with respect to the activities of fishing vessels flying the flags of states which are neither members of the organization nor participants in the arrangement and which are engaged in fishing operations for the relevant stocks. They shall take measures consistent with this agreement and international law to deter activities of such vessels which undermine the effectiveness of sub-regional or regional conservation and the management measures. Part 5. Duties of the flag state, Article 18. Duties of the flag state. 1. A state whose vessels fish on the high seas shall take such measures as may be necessary to ensure that vessels flying its flag comply with sub-regional and regional conservation and management measures and that such vessels do not engage in any activity which undermines the effectiveness of such measures. 2. A state shall authorize the use of vessels flying its flag for fishing on the high seas only where it is able to exercise effectively its responsibilities in respect of such vessels under the Convention and this agreement. 3. Measures to be taken by a state in respect of vessels flying its flag shall include a. Control of such vessels on the high seas by means of fishing licenses, authorizations or permits, in accordance with any applicable procedures agreed at the sub-regional, regional or global level. b. Establishment of regulations. I. To apply terms and conditions to the license, authorization or permit sufficient to fulfill any sub-regional, regional or global obligations of the flag state. 2. To prohibit fishing on the high seas by vessels which are not duly licensed or authorized to fish, or fishing on the high seas by vessels otherwise than in accordance with the terms and conditions of a license, authorization or permit. 3. To require vessels fishing on the high seas to carry the license, authorization or permit on board at all times and to produce it on demand for inspection by a duly authorized person and 4. to ensure that vessels flying its flag do not conduct unauthorized fishing within areas under the national jurisdiction of other states. C. Establishment of a national record of fishing vessels authorized to fish on the high seas and provision of access to the information contained in that record on request by directly interested states, taking into account any national laws of the flag state regarding the release of such information. D. Requirements for marking of fishing vessels and fishing gear for identification in accordance with uniform and internationally recognizable vessel and gear marking systems, such as the Food and Agriculture Organization of the United Nations Standards specifications for the marking and identification of fishing vessels. E. Requirements for recording and timely reporting of vessel position, catch of target and non-target species, fishing effort and other relevant fisheries data in accordance with sub-regional, regional and global standards for collection of such data. F. Requirements for verifying the catch of target and non-target species through such means as observer programs, inspection schemes, unloading reports, supervision of transshipment and the monitoring of landed catches and the market statistics. G. Monitoring, control and surveillance of such vessels, their fishing operations and related activities by, inter alia. I. The implementation of national inspection schemes and sub-regional and regional schemes for cooperation in enforcement pursuant to Articles 21 and 22, including requirements for such vessels to permit access by duly authorized inspectors from other states. 2. The implementation of national observer programs and sub-regional and regional observer programs in which the flag state is a participant, including requirements for such vessels to permit access by observers from other states to carry out the functions agreed under the programs, and 3. The development and implementation of vessel monitoring systems, including, as appropriate, satellite transmitter systems, in accordance with any national programs and those which have been sub-regionally, regionally or globally agreed among the states concerned. H. Regulation of transshipment on the high seas to ensure that the effectiveness of conservation and management measures is not undermined, and I. Regulation of fishing activities to ensure compliance with sub-regional, regional or global measures, including those aimed at minimizing catches of non-target species. 4. Where there is a sub-regionally, regionally or globally agreed system of monitoring, control and surveillance in effect, states shall ensure that the measures they impose on vessels flying their flag are compatible with that system. Part 6. Compliance and Enforcement, Article 19. Compliance and enforcement by the flag state. 1. A state shall ensure compliance by vessels flying its flag with sub-regional and regional conservation and management measures for straddling fish stocks and highly migratory fish stocks. To this end, that state shall a. Enforce such measures irrespective of where violations occur. b. Investigate immediately and fully any alleged violation of sub-regional or regional conservation and the management measures, which may include the physical inspection of the vessels concerned, and report promptly to the state alleging the violation and the relevant sub-regional or regional organization or arrangement on the progress and outcome of the investigation. c. Require any vessel flying its flag to give information to the investigating authority regarding vessel position, catches, fishing gear, fishing operations and related activities in the area of an alleged violation. d. If satisfied that sufficient evidence is available in respect of an alleged violation, refer the case to its authorities with a view to instituting proceedings without delay in accordance with its laws and, where appropriate, detain the vessel concerned, and e. Ensure that, where it has been established, in accordance with its laws, a vessel has been involved in the commission of a serious violation of such measures, the vessel does not engage in fishing operations on the high seas until such time as all outstanding sanctions imposed by the flag state in respect of the violation have been complied with. 2. All investigations and judicial proceedings shall be carried out expeditiously. Sanctions applicable in respect of violations shall be adequate in severity to be effective in securing compliance and to discourage violations wherever they occur, and shall deprive offenders of the benefits accruing from their illegal activities. Measures applicable in respect of masters and other officers of fishing vessels shall include provisions which may permit, inter alia, refusal, withdrawal or suspension of authorizations to serve as masters or officers on such vessels. Article 20. International cooperation in enforcement. 1. States shall cooperate, either directly or through sub-regional or regional fisheries management organizations or arrangements, to ensure compliance with and enforcement of sub-regional and regional conservation and management measures for straddling fish stocks and highly migratory fish stocks. 2. A flag state conducting an investigation of an alleged violation of conservation and management measures for straddling fish stocks or highly migratory fish stocks may request the assistance of any other state whose cooperation may be useful in the conduct of that investigation. All states shall endeavor to meet reasonable requests made by a flag state in connection with such investigations. 3. A flag state may undertake such investigations directly, in cooperation with other interested states or through the relevant sub-regional or regional fisheries management organization or arrangement. Information on the progress and outcome of the investigations shall be provided to all states having an interest in, or affected by, the alleged violation. 4. States shall assist each other in identifying vessels reported to have engaged in activities undermining the effectiveness of sub-regional, regional or global conservation and management measures. 5. States shall, to the extent permitted by national laws and regulations, establish arrangements for making available to prosecuting authorities in other states evidence relating to alleged violations of such measures. 6. Where there are reasonable grounds for believing that a vessel on the high seas has been engaged in unauthorized fishing within an area under the jurisdiction of a coastal state, the flag state of that vessel, at the request of the coastal state concerned, shall immediately and fully investigate the matter. The flag state shall cooperate with the coastal state in taking appropriate enforcement action in such cases and may authorize the relevant authorities of the coastal state to board and inspect the vessel on the high seas. This paragraph is without prejudice to Article 111 of the Convention. 7. States parties which are members of a sub-regional or regional fisheries management organization or participants in a sub-regional or regional fisheries management arrangement may take action in accordance with international law, including through recourse to sub-regional or regional procedures established for this purpose, to deter vessels which have engaged in activities which undermine the effectiveness of or otherwise violate the conservation and management measures established by that organization or arrangement from fishing on the high seas in the sub-region or region until such time as appropriate action is taken by the flag state. Article 21. Sub-regional and regional cooperation in enforcement. 1. In any high seas area covered by a sub-regional or regional fisheries management organization or arrangement, a state party which is a member of such organization or a participant in such arrangement may, through its duly authorized inspectors, board and inspect, in accordance with paragraph 2, fishing vessels flying the flag of another state party to this agreement, whether or not such state party is also a member of the organization or a participant in the arrangement, for the purpose of ensuring compliance with conservation and management measures for straddling fish stocks and highly migratory fish stocks established by that organization or arrangement. 2. States shall establish, through sub-regional or regional fisheries management organizations or arrangements, procedures for boarding and inspection pursuant to paragraph 1, as well as procedures to implement other provisions of this article. Such procedures shall be consistent with this article and the basic procedures set out in Article 22 and shall not discriminate against non-members of the organization or non-participants in the arrangement. Boarding and inspection as well as any subsequent enforcement action shall be conducted in accordance with such procedures. States shall give due publicity to procedures established pursuant to this paragraph. 3. If, within 2 years of the adoption of this agreement, any organization or arrangement has not established such procedures, boarding and inspection pursuant to paragraph 1, as well as any subsequent enforcement action, shall, pending the establishment of such procedures, be conducted in accordance with this article and the basic procedures set out in Article 22. 4. Prior to taking action under this article, inspecting states shall, either directly or through the relevant sub-regional or regional fisheries management organization or arrangement, inform all states whose vessels fish on the high seas in the sub-region or region of the form of identification issued to their duly authorized inspectors. The vessels used for boarding and inspection shall be clearly marked and identifiable as being on government service. At the time of becoming a party to this agreement, a state shall designate an appropriate authority to receive notifications pursuant to this article and shall give due publicity of such designation through the relevant sub-regional or regional fisheries management organization or arrangement. 5. Where, following a boarding and inspection, there are clear grounds for believing that a vessel has engaged in any activity contrary to the conservation and management measures referred to in paragraph 1, the inspecting state shall, where appropriate, secure evidence and shall promptly notify the flag state of the alleged violation. 6. The flag state shall respond to the notification referred to in paragraph 5 within 3 working days of its receipt, or such other period as may be prescribed in procedures established in accordance with paragraph 2, and shall either a. fulfill, without delay, its obligations under Article 19 to investigate and, if evidence so warrants, take enforcement action with respect to the vessel, in which case it shall promptly inform the inspecting state of the results of the investigation and of any enforcement action taken, or b. authorize the inspecting state to investigate. 7. Where the flag state authorizes the inspecting state to investigate an alleged violation, the inspecting state shall, without delay, communicate the results of that investigation to the flag state. The flag state shall, if evidence so warrants, fulfill its obligations to take enforcement action with respect to the vessel. Alternatively, the flag state may authorize the inspecting state to take such enforcement action as the flag state may specify with respect to the vessel, consistent with the rights and obligations of the flag state under this agreement. 8. Where, following boarding and inspection, there are clear grounds for believing that a vessel has committed a serious violation, and the flag state has either failed to respond or failed to take action as required under paragraphs 6 or 7, the inspectors may remain on board and secure evidence and may require the master to assist in further investigation, including, where appropriate, by bringing the vessel without delay to the nearest appropriate port, or to such other port as may be specified in procedures established in accordance with paragraph 2. The inspecting state shall immediately inform the flag state of the name of the port to which the vessel is to proceed. The inspecting state and the flag state and, as appropriate, the port state shall take all necessary steps to ensure the well-being of the crew regardless of their nationality. 9. The inspecting state shall inform the flag state and the relevant organization or the participants in the relevant arrangement of the results of any further investigation. 10. The inspecting state shall require its inspectors to observe generally accepted international regulations, procedures and practices relating to the safety of the vessel and the crew, minimize interference with fishing operations and, to the extent practicable, avoid action which would adversely affect the quality of the catch on board. The inspecting state shall ensure that boarding and inspection is not conducted in a manner that would constitute harassment of any fishing vessel. 11. For the purposes of this article, a serious violation means a. Fishing without a valid license, authorization or permit issued by the flag state in accordance with Article 18, Paragraph 3, a. b. Failing to maintain accurate records of catch and catch-related data, as required by the relevant sub-regional or regional fisheries management organization or arrangement, or serious misreporting of catch, contrary to the catch reporting requirements of such organization or arrangement. c. Fishing in a closed area, fishing during a closed season or fishing without, or after attainment of, a quota established by the relevant sub-regional or regional fisheries management organization or arrangement. d. Directed fishing for a stock which is subject to a moratorium or for which fishing is prohibited. e. Using prohibited fishing gear. f. Falsifying or concealing the markings, identity or registration of a fishing vessel. g. Concealing, tampering with or disposing of evidence relating to an investigation. h. Multiple violations which together constitute a serious disregard of conservation and management measures, or I. Such other violations as may be specified in procedures established by the relevant sub-regional or regional fisheries management organization or arrangement. 12. Notwithstanding the other provisions of this article, the flag state may, at any time, take action to fulfill its obligations under Article 19 with respect to an alleged violation. Where the vessel is under the direction of the inspecting state shall, at the request of the flag state, release the vessel to the flag state along with full information on the progress and outcome of its investigation. 13. This article is without prejudice to the right of the flag state to take any measures, including proceedings to impose penalties, according to its laws. 14. This article applies mutatis mutandis to boarding and inspection by a state party which is a member of a sub-regional or regional fisheries management organization or a participant in a sub-regional or regional fisheries management arrangement and which has clear grounds for believing that a fishing vessel flying the flag of another state party has engaged in any activity contrary to relevant conservation and management measures referred to in paragraph 1 in the high seas area covered by such organization or arrangement, and such vessel had subsequently, during the same fishing trip, entered into an area under the national jurisdiction of the inspecting state. 15. Where a sub-regional or regional fisheries management organization or arrangement has established an alternative mechanism which effectively discharges the obligation under this agreement of its members or participants to ensure compliance with the conservation and management measures established by the organization or arrangement, members of such organization or participants in such arrangement may agree to limit the application of paragraph 1 as between themselves in respect of the conservation and management measures which have been established in the relevant high seas area. 16. Action taken by states other than the flag state in respect of vessels having engaged in activities contrary to sub-regional or regional conservation and management measures shall be proportionate to the seriousness of the violation. 17. Where there are reasonable grounds for suspecting that a fishing vessel on the high seas is without nationality, a state may board and inspect the vessel. Where evidence so warrants, the state may take such action as may be appropriate in accordance with international law. 18. States shall be liable for damage or loss attributable to them arising from action taken pursuant to this article when such action is unlawful or exceeds that reasonably required in the light of available information to implement the provisions of this article. Article 22. Basic procedures for boarding and inspection pursuant to Article 21. 1. The inspecting state shall ensure that its duly authorized inspectors a. present credentials to the master of the vessel and produce a copy of the text of the relevant conservation and management measures or rules and regulations in force in the high seas area in question pursuant to those measures. B. Initiate notice to the flag state at the time of the boarding and inspection. C. Do not interfere with the master's ability to communicate with the authorities of the flag state during the boarding and inspection. D. Provide a copy of a report on the boarding and inspection to the master and to the authorities of the flag state, noting therein any objection or statement which the master wishes to have included in the report. E. Promptly leave the vessel following completion of the inspection if they find no evidence of a serious violation, and F. Avoid the use of force except when and to the degree necessary to ensure the safety of the inspectors and where the inspectors are obstructed in the execution of their duties. The degree of force used shall not exceed that reasonably required in the circumstances. 2. The duly authorized inspectors of an inspecting state shall have the authority to inspect the vessel, its license, gear, equipment, records, facilities, fish and fish products and any relevant documents necessary to verify compliance with the relevant conservation and management measures. 3. The flag state shall ensure that vessel masters, a. accept and facilitate prompt and safe boarding by the inspectors, b. cooperate with and assist in the inspection of the vessel conducted pursuant to these procedures, c. do not obstruct, intimidate or interfere with the inspectors in the performance of their duties, d. allow the inspectors to communicate with the authorities of the flag state and the inspecting state during the boarding and inspection, e. provide reasonable facilities, including, where appropriate, food and accommodation, to the inspectors and, f. facilitate safe disembarkation by the inspectors. 4. In the event that the master of a vessel refuses to accept boarding and inspection in accordance with this article and Article 21, the flag state shall, except in circumstances where, in accordance with generally accepted international regulations, procedures and practices relating to safety at sea, it is necessary to delay the boarding and inspection, direct the master of the vessel to submit immediately to boarding and inspection, and, if the master does not comply with such direction, shall suspend the vessel's authorization to fish and order the vessel to return immediately to port. The flag state shall advise the inspecting state of the action it has taken when the circumstances referred to in this paragraph arise. Article 23. Measures taken by a port state. 1. A port state has the right and the duty to take measures, in accordance with international law, to promote the effectiveness of sub-regional, regional and global conservation and management measures. When taking such measures, a port state shall not discriminate in form or in fact against the vessels of any state. 2. A port state may, inter alia, inspect documents, fishing gear and catch on board fishing vessels, when such vessels are voluntarily in its ports or at its offshore terminals. 3. States may adopt regulations empowering the relevant national authorities to prohibit landings and transshipments where it has been established that the catch has been taken in a manner which undermines the effectiveness of sub-regional, regional or global conservation and management measures on the high seas. 4. Nothing in this article affects the exercise by states of their sovereignty over ports in their territory in accordance with international law. Part 7. Requirements of developing states, Article 24. Recognition of the special requirements of developing states. 1. States shall give full recognition to the special requirements of developing states in relation to conservation and management of straddling fish stocks and highly migratory fish stocks and development of fisheries for such stocks. To this end, states shall, either directly or through the United Nations Development Programme, the Food and Agriculture Organization of the United Nations and other specialized agencies, the Global Environment Facility, the Commission on Sustainable Development and other appropriate international and regional organizations and bodies, Provide assistance to developing states. 2. In giving effect to the duty to cooperate in the establishment of conservation and management measures for straddling fish stocks and highly migratory fish stocks, states shall take into account the special requirements of developing states, in particular, a. the vulnerability of developing states which are dependent on the exploitation of living marine resources, including for meeting the nutritional requirements of their populations or parts thereof. b. The need to avoid adverse impacts on, and ensure access to fisheries by, subsistence, small-scale and artisanal fishers and women fish workers, as well as indigenous people in developing states, particularly small island developing states, and c. The need to ensure that such measures do not result in transferring, directly or indirectly, a disproportionate burden of conservation action onto developing states. Article 25. Forms of cooperation with developing states. 1. States shall cooperate, either directly or through sub-regional, regional or global organizations. a. To enhance the ability of developing states, in particular the least developed among them and small island developing states, to conserve and manage straddling fish stocks and highly migratory fish stocks and to develop their own fisheries for such stocks. b. To assist developing states, in particular the least developed among them and small island developing states, to enable them to participate in high seas fisheries for such stocks, including facilitating access to such fisheries subject to Articles 5 and 11, and c. To facilitate the participation of developing states in sub-regional and regional fisheries management organizations and arrangements. 2. Cooperation with developing states for the purposes set out in this article shall include the provision of financial assistance, assistance relating to human resources development, technical assistance, transfer of technology, including through joint venture arrangements, and advisory and consultative services. 3. Such assistance shall, inter alia, be directed specifically towards a. Improved conservation and management of straddling fish stocks and highly migratory fish stocks through collection, reporting, verification, exchange and analysis of fisheries data and related information. b. Stock assessment and scientific research and c. Monitoring, control, surveillance, compliance and enforcement, including training and capacity building at the local level, development and funding of national and regional observer programs and access to technology and equipment. Article 26. Special assistance in the implementation of this agreement. 1. States shall cooperate to establish special funds to assist developing states in the implementation of this agreement, including assisting developing states to meet the costs involved in any proceedings for the settlement of disputes to which they may be parties. 2. States and international organizations should assist developing states in establishing new sub-regional or regional fisheries management organizations or arrangements, or in strengthening existing organizations or arrangements, for the conservation and management of straddling fish stocks and highly migratory fish stocks. Part 8. Peaceful settlement of disputes, Article 27. Obligation to settle disputes by peaceful means. States have the obligation to settle their disputes by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice. Article 28. Prevention of disputes. States shall cooperate in order to prevent disputes. To this end, states shall agree on efficient and expeditious decision-making procedures within sub-regional and regional fisheries management organizations and arrangements and shall strengthen existing decision-making procedures as necessary. Article 29. Disputes of a technical nature. Where a dispute concerns a matter of a technical nature, the states concerned may refer the dispute to an ad hoc expert panel established by them. The panel shall confer with the states concerned and shall endeavor to resolve the dispute expeditiously without recourse to binding procedures for the settlement of disputes. Article 30. Procedures for the settlement of disputes. 1. The provisions relating to the settlement of disputes set out in Part 15 of the Convention apply mutatis mutandis to any dispute between states parties to this agreement concerning the interpretation or application of this agreement, whether or not they are also parties to the Convention. 2. The provisions relating to the settlement of disputes set out in Part 15 of the Convention apply mutatis mutandis to any dispute between states parties to this agreement concerning the interpretation or application of a sub-regional, regional or global fisheries agreement relating to straddling fish stocks or highly migratory fish stocks to which they are parties, including any dispute concerning the conservation and management of such stocks, whether or not they are also parties to the Convention. 3. Any procedure accepted by a state party to this agreement and the Convention pursuant to Article 287 of the Convention shall apply to the settlement of disputes under this part, unless that state party, when signing, ratifying or acceding to this agreement, or at any time thereafter, has accepted another procedure pursuant to Article 287 for the settlement of disputes under this part. 4. A state party to this agreement which is not a party to the Convention, when signing, ratifying or acceding to this agreement, or at any time thereafter, shall be free to choose, by means of a written declaration, one or more of the means set out in Article 287, paragraph 1, of the Convention for the settlement of disputes under this part. Article 287 shall apply to such a declaration, as well as to any dispute to which such state is a party which is not covered by a declaration in force. For the purposes of conciliation and arbitration in accordance with Annexes V, 7 and 8 to the Convention, such state shall be entitled to nominate conciliators, arbitrators and experts to be included in the lists referred to in Annex V, Article 2, Annex 7, Article 2, and Annex 8, Article 2, for the settlement of disputes under this part. 5. Any court or tribunal to which a dispute has been submitted under this part shall apply the relevant provisions of the Convention, of this agreement and of any relevant sub-regional, regional or global fisheries agreement, as well as generally accepted standards for the conservation and management of living marine resources and other rules of international law not incompatible with the Convention, with a view to ensuring the conservation of the straddling fish stocks and highly migratory fish stocks concerned. Article 31. Provisional measures. 1. Pending the settlement of a dispute in accordance with this part, the parties to the dispute shall make every effort to enter into provisional arrangements of a practical nature. 2. Without prejudice to Article 290 of the Convention, the court or tribunal to which the dispute has been submitted under this part may prescribe any provisional measures which it considers appropriate under the circumstances to preserve the respective rights of the parties to the dispute or to prevent damage to the stocks in question, as well as in the circumstances referred to in Article 7, paragraph 5, and Article 16, paragraph 2. 3. A state party to this agreement which is not a party to the Convention may declare that, notwithstanding Article 290, paragraph 5, of the Convention, the International Tribunal for the Law of the Sea shall not be entitled to prescribe, modify or revoke provisional measures without the agreement of such state. Article 32. Limitations on applicability of procedures for the settlement of disputes. Article 297, paragraph 3, of the Convention applies also to this agreement. Part 9. Non-parties to this agreement. Article 33. Non-parties to this agreement. 1. States parties shall encourage non-parties to this agreement to become parties thereto and to adopt laws and regulations consistent with its provisions. 2. States parties shall take measures consistent with this agreement and international law to deter the activities of vessels flying the flag of non-parties which undermine the effective implementation of this agreement. Part 10. Good faith and abuse of rights, Article 34. Good faith and abuse of rights. States parties shall fulfill in good faith the obligations assumed under this agreement and shall exercise the rights recognized in this agreement in a manner which would not constitute an abuse of right. Part 11. Responsibility and liability, Article 35. Responsibility and liability. States parties are liable in accordance with international law for damage or loss attributable to them in regard to this agreement. Part 12. Review Conference, Article 36. Review Conference, 1. 4 years after the date of entry into force of this agreement, the Secretary-General of the United Nations shall convene a conference with a view to assessing the effectiveness of this agreement in securing the conservation and management of straddling fish stocks and highly migratory fish stocks. The Secretary-General shall invite to the conference all states parties and those states and entities which are entitled to become parties to this agreement, as well as those intergovernmental and non-governmental organizations entitled to participate as observers. 2. The conference shall review and assess the adequacy of the provisions of this agreement and, if necessary, propose means of strengthening the substance and methods of implementation of those provisions in order better to address any continuing problems in the conservation and management of straddling fish stocks and highly migratory fish stocks. Part 13. Final Provisions, Article 37. Signature. This agreement shall be open for signature by all states and the other entities referred to in Article 1. Paragraph 2b, and shall remain open for signature at United Nations headquarters for 12 months from the 4th of December 1995. Article 38. Ratification. This agreement is subject to ratification by states and the other entities referred to in Article 1, Paragraph 2b. The instruments of ratification shall be deposited with the Secretary-General of the United Nations. Article 39. Accession. This agreement shall remain open for accession by states and the other entities referred to in Article 1, Paragraph 2b. The instruments of accession shall be deposited with the Secretary-General of the United Nations. Article 40. Entry into force. 1. This agreement shall enter into force 30 days after the date of deposit of the 30th instrument of ratification or accession. 2. For each state or entity which ratifies the agreement or accedes thereto after the deposit of the 30th instrument of ratification or accession, this agreement shall enter into force on the 30th day following the deposit of its instrument of ratification or accession. Article 41. Provisional Application. 1. This agreement shall be applied provisionally by a state or entity which consents to its provisional application by so notifying the depository in writing. Such provisional application shall become effective from the date of receipt of the notification. 2. Provisional application by a state or entity shall terminate upon the entry into force of this agreement for that state or entity or upon notification by that state or entity to the depository in writing of its intention to terminate provisional application. Article 42. Reservations and exceptions. No reservations or exceptions may be made to this agreement. Article 43. Declarations and statements. Article 42 does not preclude a state or entity, when signing, ratifying or acceding to this agreement, from making declarations or statements, however phrased or named, with a view, inter alia, to the harmonization of its laws and regulations with the provisions of this agreement, provided that such declarations or statements do not purport to exclude or to modify the legal effect of the provisions of this agreement in their application to that state or entity. Article 44. Relation to other agreements. 1. This agreement shall not alter the rights and obligations of states parties which arise from other agreements compatible with this agreement and which do not affect the enjoyment by other states parties of their rights or the performance of their obligations under this agreement. 2. Two or more states parties may conclude agreements modifying or suspending the operation of provisions of this agreement, applicable solely to the relations between them, provided that such agreements do not relate to a provision derogation from which is incompatible with the effective execution of the object and purpose of this agreement, and provided further that such agreements shall not affect the application of the basic principles embodied herein, and that the provisions of such agreements do not affect the enjoyment by other states parties of their rights or the performance of their obligations under this agreement. 3. States parties intending to conclude an agreement referred to in paragraph 2 shall notify the other states parties through the depository of this agreement of their intention to conclude the agreement and of the modification or suspension for which it provides. Article 45. Amendment 1. A state party may, by written communication addressed to the Secretary-General of the United Nations, propose amendments to this agreement and request the convening of a conference to consider such proposed amendments. The Secretary-General shall circulate such communication to all states parties. If, within 6 months from the date of the circulation of the communication, not less than 1/2 of the states parties reply favorably to the request, the Secretary-General shall convene the conference. 2. The decision-making procedure applicable at the amendment conference convened pursuant to paragraph 1 shall be the same as that applicable at the United Nations Conference on Straddling Fish Stocks and Highly Migratory Fish Stocks, unless otherwise decided by the conference. The conference should make every effort to reach agreement on any amendments by way of consensus, and there should be no voting on them until all efforts at consensus have been exhausted. 3. Once adopted, amendments to this agreement shall be open for signature at United Nations headquarters by states parties for 12 months from the date of adoption, unless otherwise provided in the amendment itself. 4. Articles 38, 39, 47 and 50 apply to all amendments to this agreement. 5. Amendments to this agreement shall enter into force for the states parties ratifying or acceding to them on the 30th day following the deposit of instruments of ratification or accession by 2/3 of the states parties. Thereafter, for each state party ratifying or acceding to an amendment after the deposit of the required number of such instruments, the amendment shall enter into force on the 30th day following the deposit of its instrument of ratification or accession. 6. An amendment may provide that a smaller or a larger number of ratifications or accessions shall be required for its entry into force than are required by this article. 7. A state which becomes a party to this agreement after the entry into force of amendments in accordance with paragraph 5 shall, failing an expression of a different intention by that state, a. be considered as a party to this agreement as so amended, and b. be considered as a party to the unamended agreement in relation to any state party not bound by the amendment. Article 46. Denunciation 1. A state party may, by written notification addressed to the Secretary-General of the United Nations, denounce this agreement and may indicate its reasons. Failure to indicate reasons shall not affect the validity of the denunciation. The denunciation shall take effect 1 year after the date of receipt of the notification, unless the notification specifies a later date. 2. The denunciation shall not in any way affect the duty of any state party to fulfill any obligation embodied in this agreement to which it would be subject under international law independently of this agreement. Article 47. Participation by international organizations. 1. In cases where an international organization referred to in Annex 9, Article 1, of the Convention does not have competence over all the matters governed by this agreement, Annex 9 to the Convention shall apply mutatis mutandis to participation by such international organization in this agreement, except that the following provisions of that annex shall not apply. A. Article 2, first sentence and B. Article 3, paragraph 1. 2. In cases where an international organization referred to in Annex 9, Article 1, of the Convention has competence over all the matters governed by this agreement, the following provisions shall apply to participation by such international organization in this agreement. A. At the time of signature or accession, such international organization shall make a declaration stating I. That it has competence over all the matters governed by this agreement. 2. That, for this reason, its member states shall not become states parties, except in respect of their territories for which the international organization has no responsibility, and 3. That it accepts the rights and obligations of states under this agreement. B. Participation of such an international organization shall in no case confer any rights under this agreement on member states of the international organization. C. In the event of a conflict between the obligations of an international organization under this agreement and its obligations under the agreement establishing the international organization or any acts relating to it, the obligations under this agreement shall prevail. Article 48. Annexes. 1. The annexes form an integral part of this agreement and, unless expressly provided otherwise, a reference to this agreement or to one of its parts includes a reference to the annexes relating thereto. 2. The annexes may be revised from time to time by states parties. Such revisions shall be based on scientific and technical considerations. Notwithstanding the provisions of Article 45, if a revision to an annex is adopted by consensus at a meeting of states parties, it shall be incorporated in this agreement and shall take effect from the date of its adoption or from such other date as may be specified in the revision. If a revision to an annex is not adopted by consensus at such a meeting, the amendment procedures set out in Article 45 shall apply. Article 49. Depository. The Secretary-General of the United Nations shall be the depository of this agreement and any amendments or revisions thereto. Article 50. Authentic texts. The Arabic, Chinese, English, French, Russian and Spanish texts of this agreement are equally authentic. In witness whereof, the undersigned plenipotentiaries, being duly authorized thereto, have signed this agreement. Opened for signature at New York, this 4th day of December, 1995, in a single original, in the Arabic, Chinese, English, French, Russian and Spanish languages.